MillerCoors strikes back. What does a company that was built around its opposition to big beer do when it becomes big beer? Stone Brewing's solution appears to be to file this meritless lawsuit against MillerCoors. Stone Brewing hopes that this lawsuit will help them stand out in an increasingly crowded craft beer market. Wow. And this is Beer Esquire, looking at the intersection between beer and law. I previously covered this suit in February after Stone filed a complaint that alleges Keystone's redesigned cans and recent advertising infringe upon Stone's trademark. In the last half of that video, I predicted MillerCoors' defenses, and they've come to pass. MillerCoors has two main arguments. First, that they don't infringe because they haven't actually taken the key out of Keystone at all. They attack Stone for not including actual photos of the cans and instead relying on pictures of the cans in advertising and on Keystone boxes, which appear to show cans that just say Stone. Actual cans don't look like that. Their second big argument is laches, which is an equitable doctrine to prevent people from unfairly surprising and harming each other. Basically, if you know about somebody using something that you believe belongs to you, and you let them do it for a long time, and you do it knowingly, they have a laches defense to prevent you from jumping in years later and harming their investment. Here, as my previous video observed, we know that MillerCoors' use of the words Stone and Stones was known to Stone Brewing Company. If nothing else, this was clear in 2010 when MillerCoors filed an application for a trademark over Hold My Stones. Stone Brewing Company filed for several extensions of time to respond to the Hold My Stones trademark application, but MillerCoors mysteriously dropped the application, expressly abandoned it in November 2010. We now know a little bit more about what happened. In particular, Stone Brewing sent MillerCoors a cease and desist letter in 2010, and MillerCoors apparently responded 2 weeks later. According to the counterclaims, MillerCoors made clear to Stone Brewing its intention to continue using Stone and Stones in advertising campaigns for Keystone. And boy did they do that.
Hold my stones.
MillerCoors never ceased nor desisted. Instead, in November 2010, after they mysteriously disclaimed their registration for Hold My Stones, Stone Brewing a letter allegedly informing them that it would not agree to modify its marketing campaigns for Keystone or otherwise stop its use of Stone, Stones, and Hold My Stones. And this presents a pretty strong laches defense. In addition to non-infringement and laches, MillerCoors tees up a prior use kind of argument, or a senior use of the trademark. MillerCoors inserts an image of boxes of Keystone that they packaged in 1995 before Stone Brewing Company even started, and on the packages that says 30 Stones. So here they're referring to Stones as sort of individual cans of Keystone Light, and they allege that they've done this continuously since 1995, which is again before Stone Brewing Company was even incorporated. They also purport to have some advertising from even earlier than that that refers to Stone with an apostrophe in front, but they assert that this use of Stones on the packages has occurred continuously since 1995. And I see a lot of confusion on Twitter and Reddit about why this even matters. Stone Brewing Company got their trademark registered in 1998, and it wasn't contested. It's now in contestable status. They've got this trademark, and doesn't that mean, therefore, no one else can use Stone in beer and lager? Well, no, not necessarily. Whatever common law rights to trademarks exist, they exist even after a trademark is registered. The registration just means that nobody else can come along and they start selling Stone. So if it's true that MillerCoors, then just Coors, had perfected a common law right to use Stone as a sort of advertising trademark, if that's true and they hadn't abandoned it, in theory they could keep on using it. So all three of these defenses are pretty interesting, and they all cover slightly different ground. For example, the court decides in favor of laches and in favor of the senior use of 30 Stones on the boxes and says, well, saying 30 Stones on the boxes is fine, but maybe you then still argue that the cans still raise sufficient likelihood of confusion that infringement of these new designs should still be found. These are separate questions. They could be separately decided on the merits. So overall, MillerCoors has some pretty decent defenses here, but their response to the complaint is not a complete slam dunk. They've got some really goofy arguments in here. For example, they claim that it's very hard to find anyone that would buy Keystone and Stone Brewing Company beers. They say that Keystone is sold mostly in Texas, whereas Stone Brewing Company is sold mostly in the coast. But they also acknowledge that Stone is sold in all 50 states, as is Keystone. So these are just sort of awkward facts that they put in there to try to argue against some of Stone's strongest factors in favor of finding a likelihood of confusion, specifically that they're selling the same stuff, basically, beer, and they're selling it in the same stores in many cases. And in some states, they even have the same distributor. This is admitted. So they had to put in some facts, I guess, to sort of push back on these. On the other hand, maybe not. I mean, it's just such a junk argument, I would have just kept it out. There's also this bit where they call Blue Moon a craft brewery. Of course, a lot of people would disagree with that, but the point is that MillerCoors is fashioning itself as a large craft brewer like Stone, which is also an awkward point because if MillerCoors is a craft brewery, or at least if they make stuff that is craft, according to them, then more likely for consumers to confuse products of Coors and products of Stone Brewing. Anyways, Miller's response was just not a response to the complaint. It's also counterclaims. And counterclaims are basically where you're asserting causes of action against the person that sued you. It's basically as if Coors went out and sued Stone over several issues. And they have 4 counterclaims. They want a declaratory judgment that they can continue using Stone and Stones in advertising of Keystone. And they want a declaratory judgment that their use of Stones is protected by laches. A declaratory judgment, by the way, is basically an order by the court finding a legal relationship between the parties. It's different than an injunction that actually orders the parties to do something. Instead, it's just finding that, yes, you have a meritorious laches defense. Third, they seek a declaratory judgment of non-infringement, which is completely unsurprising. Actually, accused infringers basically always do this. It's called a compulsory counterclaim. And if MillerCoors is successful in all 3 of these counterclaims, they would have judicial order expressly saying that what they're doing with their current marketing, current packaging, current design of Keystone is fine. That basically Stone has no rights to stop them legally from doing that. And if that were to occur, if they got these declaratory judgments, this entire suit would be a complete waste for Stone Brewing. So that's fine. But in their 4th counterclaim, MillerCoors goes nuclear. They want a declaratory judgment that MillerCoors, not Stone, has exclusive rights to the Stone trademark in the United States. What on earth could be the basis for this counterclaim? Well, MillerCoors quotes a 2017 interview of Stone founder Greg Cook denigrating the bitter beer face of the Keystone Light ads, which are basically advertising how unhappy Keystone is. And MillerCoors leaps from this to the conclusion that it's more likely Stone Brewing copied the Stone name from Coors since Keystone beer was already advertised as such in the market. This counterclaim seems incredibly weak. It's also a little bit of a distraction because they aren't seeking an injunction that Stone can stop using their trademark. Even if MillerCoors owned the trademark for Stones, Stone Brewing Company could still use it because they have an even stronger laches defense than MillerCoors does. I mean, MillerCoors' defense is quite colorable because Stone Brewing did nothing after finding out about their Hold My Stones trademark in 2010. Well, Stone Brewing Company's trademark goes back to 1998. Of course, they have an awesome laches defense. So it's hard to see how this would even impact the marketplace. There is almost no hope for this claim to succeed. So why does MillerCoors plead it? Well, I think they're trying to get leverage for a favorable settlement. By including this claim, they broaden the scope of discovery all the way back to Stone Brewing Company's founding. This means that MillerCoors will get to search basically all email Stone possesses in a reasonably recoverable format and possibly depose former employees maybe disgruntled, who have left the company a long time ago. In other words, this counterclaim imposes direct money cost on Stone Brewing in terms of getting paper discovery from email and so forth. And it also gives MillerCoors a larger chance of uncovering potentially embarrassing details. If you'd like to read some great commentary on the complaint, I recommend Brendan Palfreyman's Twitter thread, linked in the description below. So, what happens now? Well, the first thing is there's this minor technical issue that Stone Brewing Company sued MillerCoors, and apparently there's no personal jurisdiction over that corporation. It's apparently just a holding company for MillerCoors in the United States. And so the parties have stipulated to dismiss MillerCoors. This is a completely unremarkable kind of motion. And if it turns out in the course of discovery that MillerCoors, the parent company, was more involved in Keystone than the declaration lets on, well, they'll be back in the complaint. No big deal. It doesn't really interfere with the substantive litigation between MillerCoors and Stone Brewing. Next, Stone Brewing will answer MillerCoors' counterclaims. Responses to counterclaims are normally due within 21 days, but MillerCoors got 2 extensions for their answer, so Stone's reply, that probably comes earliest late April, I think more likely in May. And then what happens after that? Well, in the typical case in the Southern District of California, there will be an early neutral evaluation conference where a magistrate judge tries to figure out if the case is going to settle. Basically talks to the party and try to determine if there's a likelihood of settlement, and if there is, the case will be stayed and they'll settle. If not, there would be an initial scheduling conference, which will really kick off discovery and potentially very large attorney's fees. But Stone issued a statement, and their attorney suggested that this case is not going to follow the normal path. His statement says that the case will now proceed to likely preliminary injunction hearing. For that to occur, Stone Brewing is apparently going to file a motion for preliminary injunction. And you might be asking, what is a preliminary injunction? Basically, it's an order issued toward the beginning of the case that prevents the party from doing something. That's what an injunction generally is. Preliminary means it's before the actual trial on the merits. When a party files a motion for a preliminary injunction, typically the court sets a very accelerated schedule to decide it. Something like a month is typical. And for perspective, a trial would take, at least 18 months, probably years to occur. So preliminary injunction is lightning fast compared to civil litigation. A preliminary injunction hearing is like a mini trial on the merits, and that's because the party must show that they are likely to prevail on the underlying complaint. So Stone would have to show that they're likely to win their trademark infringement suit. But not just that. To get preliminary injunction, you also have to show a probability, not just a possibility, a probability that there will be irreparable harm. Given how fact-intensive trademark infringement actions are, unless you're dealing with stuff like actual counterfeits, it's hard to see a preliminary injunction being issued in this case. Stone might just be hoping for a quick settlement, because by filing for preliminary injunction, it makes all the lawyers scramble, and maybe they were reckoning MillerCoors would just, change their cans in order to avoid the cost of a 1-month crunch where tons of attorneys are billing tons of time. But in any case, we may soon see if this is one of the 1% trademark cases that gets to a decision on the merits. Thanks for watching. If you'd like to see more videos like this one, hit subscribe, or watch one of the other ones I have linked below. Thanks again.